All right, welcome Consumer Law 101 students and scholars. We're here today in our 10th and final video under the FCRA lecture video series. And this 10th video is entitled Consumers Fighting Back, the Secrets and Power of FCRA Litigation. As you probably know by now, my name is Aaron Swift and I am the CEO and managing partner of Swift Law North and Consumer Law 101. Today's agenda for this 10th video, we're going to talk about what is involved with FCRA litigation, just kind of talk high level stuff. Then talk the power of the different damages and other benefits to the consumer, timing and other expectation management. And lastly, we're going to again tie a bow, connect this all to credit repair. So let's dive right in. So generally speaking, what's involved in federal court FCRA litigation? And that's the first part. This is always or almost always going to end up in federal court. There's a legal issue called concurrent jurisdiction that says you can file these cases in state court, but because it's a federal law, the Fair Credit Reporting Act, most defendants will then what's called remove the case from state court to federal court, and that takes time. So actually, we just file straight in federal court. But because of that, we have to think about what that means. The same federal judge who's going to have our case, whether it's an FDCP case or we're talking here FCRA litigation, they have capital murder, like death penalty cases. So you can kind of tell they may not like our cases a lot. They think these, common law, civil law, financial cases, a lot of judges look down on them or think that we clog up the courts, but it's just as important. It's a federal law and judges may not like these cases, but juries do. So usually you're filing multiple defendants. You've got a jury pool of registered voters. So they're pretty sophisticated in terms of your jury pool, and it's going to take a long time. All right, so what are the power, or what are the secrets, and what is the power of FCRA litigation? Well, really, it's in what are the damages available? What are the remedies that are available to the consumer? So first is, if a defendant violates the statute, they can be liable for what's called a statutory damage. That's something between $100 and $1,000 per defendant per violation. It's not super sexy, it's not life-changing money, but it's enough of a penalty that it gets some attention and it's important. On top of that, you can get actual damages, and actual damages can be either economic actual damages, the money spent sending dispute letters and certified mailing costs, time out of work to deal with these issues, if there's other hard, money costs. But you can have non-economic actual damages, which would be like pain and suffering, emotional distress, frustration. And of course, these cases can have a lot of those types of damages when you're talking about not being able to qualify for loans or losing, out on a job. So non-economic actual damages are very material in these cases. And then one of the biggest leverage points for consumers is if you can prove that the defendants have acted willfully or recklessly, and not just negligently, then you can get the jury to decide on punitive damages. That's why we stress a lot of disputes, very clear information, because the more chances to fix, the more chances they don't fix it, because again, we know that they often verify information that they shouldn't. A lot of these defendants, the more times that happens, the more reckless and willful their conduct, the better chance to get punitive damages, which can be quite significant. On top of that, these other great client outcomes, usually going to get, as part of a settlement, the debt gone, the debt waived, and trade line deletion, which is really the whole purpose of this, right? To improve the credit. And on top of that, and this is, keep this a little bit between us, when you settle with the CRA defendants in these cases, what they do is they give you a copy of a current credit report, and then you and the consumer have to review it to say, no, this is all accurate. This is 100%, and you're going to sign a settlement agreement to that. So sometimes you can kind of say, these other accounts, I don't really agree with them. You need to delete those as well. And that can be an extra added benefit. And then lastly, we've harped on this so many different times. Once these files get into litigation, the consumers never pay out of pocket. We finance the litigation at Swift Law North. Other consumer attorneys do the same. And then the fees and costs are paid by the bad guys. And obviously that's super important. Another very important thing is to talk about timing and expectation management. So first of all, most cases do settle early. These cases take a couple months to work themselves out, to get the facts together, to do disputes, get responses. But then once they're filed, most of them are settled early, but not all. So we have to prepare clients and consumers that these cases can take 2+ years. That's why it's super important to understand at the very beginning when we're talking to consumers, if you're going to implement the Swift Law North litigation program, is we need to know how quickly the consumer needs credit. Because litigation can take a long time. If you're tied up in litigation for 2+ years, that may hamper your ability to get other types of credit or move forward with certain things that you want to. So that's a very important consideration. It's not necessarily quick. It's effective and powerful, but FCRA litigation itself is not always quick. There are real and serious deadlines and events in these cases too. We have to prepare the consumer for, hey, you might have to show up for a deposition. You may have to sit for a mediation. You're going to be actively involved in this case, responding to discovery requests, but it is so worth it. On one hand, the process is a filtering mechanism. If a consumer is not going to be engaged and participate, send in responses, sign letters and stuff, well then we know to filter them out, because that same person who's not the most reliable pre-suit, you can't have them not show up for a deposition. You can get fined and sanctioned and held in contempt of court for missing deadlines in federal court. So this is real serious stuff. But at the end of the day, the benefits truly do pay off. It's super important to keep that in mind. All right, so again, how does this all connect? And really, what are the secrets and power? And this is really the nitty gritty. As I've said several times, as you're going to hear me say, other instructors say, litigation-backed credit repair is the best and most reliable way to improve credit. These are laws that found these principles, right? So you need lawyers, you need legal analysis, you have to be able to interpret these laws. And first of all, you're watching this video, right? So you've already done the right thing. You're taking your own education of these consumer principles into your own hands. Bravo. But let's put it into the bigger picture, right? Every one of these potential issues, every consumer is by law entitled to a credit report that is complete and accurate and the maximum possible accuracy. That's generally why they found you, these consumers. It's generally why they find us, although they find you a lot more. It's because there are issues on their credit report or issues with debt, issues with collectors they don't recognize. And the whole purpose of Consumer Law 101, the whole reason we started it, is to give you the tools, the understanding, the foundational knowledge of these consumer protection statutes. Because once you know the foundational pieces, then you can implement them with the help of lawyers to get the best outcomes for our clients and our consumers. The power of this litigation is you can force their hand. I don't know how many times you or all of my, consumers, get upset when they send in disputes. Our, credit repair partners get upset. They say we dispute and we know we're right. It just doesn't work and doesn't work. Well, guess what? Either you're going to give up or you're going to file a lawsuit. And lawsuit is the way to go. The secrets and power is you don't have to just hit a roadblock. You don't have to get frustrated. You don't have to refund client money or deal with chargebacks because you hit a dead wall or a dead end on an issue that should be fixed. Embrace these principles. Partner with lawyers like us at Swift Law North, because litigation is the key. You get them in federal court. You have the leverage of them paying their fees for their own high-priced lawyers, but then also the consumer fees at the end of the day. And again, this is all about improving lives, improving client outcomes. These lawsuits, even though they're serious and they may take some time, they can have life-changing amounts of money. We're going to learn some of that, hopefully, when you buy the extra credit content to hear some amazing case examples. But the whole purpose is get the credit reports accurate, complete, and clean, as they should be. That's what the law says. Then on top of that, compensate the consumers, in material damages. We can thousands, tens, hundreds of thousands of dollars in these cases. And that's on top of fixing their reports, which, if nothing else, a lot of these cases are going to end up with, trade line deletions, debt forgiveness, which is really what the clients wanted in the first place. So again, thank you so much. Great job, getting through the first 10 videos. Hope you buy and purchase the extra credit content. And then the higher levels, you're basically done now with the base level courses. Get to the advanced and pro levels, and then also scholars. So thank you so much. We really appreciate, let me get you to that final screen here. Keep watching our videos. Visit consumerlaw101.com for more information about our videos, scholar series. And then if you're interested in our litigation program, go to swiftlawnorth.com. Thank you.